This is Reasonable Measures podcast number 18, which is amazing that we're up that high. And today is kind of special. So instead of Tim and I chit-chatting about the latest and greatest in trade secrets, we have Ray Miller, who's a partner at DLA Piper, a chair of their life science practice, and a friend and colleague of mine for 20 or 21 years now. It's kind
Yeah,
of
20
scary.
plus years for sure. Yeah, 20 plus years. So glad
Well,
to be here.
it's great to have you here. And it's good to get a different perspective on how trade secrets fit into people's practice. And as a general framework, we're talking about M&A. Because I'm really curious about what kind of trends you've seen, Ray, in terms of like for
Cool.
M&A, do people care about trade secrets? Is it becoming a real valued asset class when you're negotiating an M&A? And just what kind of trends are you seeing?
Yeah, it is definitely becoming a real asset class. And, when you get into these transactions, traditionally, people would ask you whether you had trade secrets. You would say yes. And that would be the end of the inquiry, right? But it's really kind of expanded beyond that. People are digging into what are the policy and procedures that you have in place? How are you protecting your key assets? It gets into discussions on key employees. So in an M&A transaction, we're both patent lawyers by training. And, 15 or 20 years ago, all we would focus on are the patents and the patent claims and freedom to operate. And that's kind of completely transitioned where there's this balanced approach from, of course, people are thinking about patents, but recognizing that as we're entering this era where, it's a knowledge-based economy, how are you protecting your trade secrets and how are you making sure that your key employees are there? And if they do depart, have they taken anything that's of value?
Well, 20 years ago, when you and I first met, I was working at the molecular probes part of
Yeah.
Invitrogen. And we were doing a lot of M&A, especially
Yeah.
on the nanocrystal
Yeah.
portfolio. And we kind of knew that there were trade secrets there, but I don't think we even called them trade secrets. It was more like, witchcraft about how you get these processes to work. And, in hindsight, 20 years later,
Yeah.
we were rolling in trade secrets and we just didn't know and we weren't paying attention.
Well, it's interesting. You take the molecular probes as an example. If I could probably still find the due diligence reports that we did back then, and they were very, very patent heavy.
Of
If
course.
you remember, there were certain inventors that we were following. The names would come back to me if I thought about it. But in reality, those patent portfolios didn't turn out to be the value. I mean, how you made a quantum dot, actually being able to do it was the real value. And so, and those didn't come into play that, the economic value of the quantum dots didn't really mature for 15 or 20 years after we were looking at the acquisitions. So the patents were, for the most part, old and cold. Of course, we built portfolios around the improvements, but what people were buying back then, what Invitrogen was acquiring, what molecular probes was acquiring, in a lot of ways, was the know-how and the trade secrets.
And those are really the people. And
Yeah.
we found this with a couple of the later acquisitions where, it was really a couple of key employees that you were buying for a lot of money. And they were the only people who had the magic dust that they could, sprinkle on the bottles and get the magic to happen.
Yeah.
And you could read all four corners of the patents and not be able to replicate some of those results that these scientists and engineers could do in their sleep. So again, it's kind of funny thinking back
Yeah.
how many trade secrets we had that we really didn't pay a lot of attention to and certainly didn't assign value like we would if we were doing it today.
Absolutely. And it's funny because I can follow, I think, well, I was representing BioCrystal and then Crystalplex, and that became part of Mojo Vision. And all along the way, the trade secrets became more and more prominent. And I won't name the individual, but there was an individual at Molecular Probes who ended up at one of the key companies. And it really was because he was the only guy that could, ultimately make the
That's
quantum
right.
dot. So it was very cool. And it's, if you think about it, what we were thinking about as being important was freedom to operate. Those paths that we were looked at didn't matter because those things didn't come to market for 15 years later, right?
Right.
And then we were the second consideration was how big was our patent portfolio. What we really should have been thinking about is, how do we document and how do we make sure that the trade secrets stay with the entities?
Well, and nowadays, if you had a client come to you on either side of an M&A, like what advice are you giving them on how to handle key employees and to make sure that those valuable trade secrets don't get, laid off or demoralized or just leave the company?
Yeah, so it's both the entrance and the exit interview, and sort of reminding those employees and reminding their next employer of the value of our trade secrets, that we really we appreciate the contributions that employee X has made, but we want you to recognize that he was involved in these key programs. And so we've gotten to that point where, on occasion, if it becomes a key employee who has moved to another company, to remind that company that we have no issue with the fact that he went there, but just make sure that they understand the broad categories of areas that we consider important to us. Um,
And if
yeah,
you're representing the acquiring company, like how do you help them? Well, first identify who the key employees are, and then also make sure that they're retained as part of the integration. And we always joked that acquisition is easy and integration is hard. And I
yeah,
think a
absolutely.
lot of times that's true.
Yeah, it's interesting. Where we start generally is we will start with the patent portfolio to see who the key contributors are to the patent portfolio, and from an historical perspective, and then follow those people forward. I mean, we have companies where truly the only value, and they have considerable value, are the trade secrets and the employees that are associated with them. So it's become a much bigger issue. And you're seeing on diligence programs where, for big companies, for big pharma companies, where they're now aware of the trade secret issues, where before you wouldn't get those questions. They wouldn't ask us to look into the key employees. They wouldn't ask us to track them. And I think what has happened is a couple of these guys have gotten burnt, because they didn't retain or integrate the key employee. Um, and then all of a sudden, key employee is at company Y and they're creating something entirely competitive.
And do you find a lot of the trade secrets are in the manufacturing? So not so much in the R&D, but more, scale up and pilot plants going to full stage manufacturing. Yeah, it's a lot different making a metric ton versus 10 grams.
It is. And I will tell you, the one thing I notice about myself is I tend to gravitate towards the technical trade secrets. Those are comfortable for me, as a chemist or, an
Me
engineer on
too.
our team. But I always have to sort of step back and really ask, are there other trade secrets here that normally don't come into my consideration? The key customer relationships, the supply chain relationships, and those can be just as valuable as the technical. I think you and I, because of our science background, tend to, hold up the technical trade secrets. So yeah, I'm always looking for the I'm looking at manufacturing, right? But I'll give you an example where it's come onto my radar is the interaction with the FDA. On the life science companies. How are you interacting with the FDA? What are the testing guidelines that you're laying out for your clinical trials? Um, and we've had an increased effort, uh, partly because of the sort of radical transparency that the FDA has decided to sort of release CRL letters, but um, partly in response to that. But we've seen a much deeper dive into making sure that they keep information confidential, that it's designated as such, they understand that it is a trade secret, and or it's confidential to the company.
Well, and that goes back to the Vanda litigation that Nicole and I talked on, I
Yeah,
think it was an IHC CLE maybe a year ago or so. But it was
yeah,
really an interesting idea that a government agency could potentially release trade secrets.
Well,
Historically, people didn't worry about that.
yeah, the Vandal litigation, and then this just sort of the decision by the FDA recently, through the Trump administration to become radical, what they call radically transparent, right? Which is great, except if you think about it, they use this to ameliorate our concern over trade secrets. They basically go in and black out, areas of sensitive information. But if you think about AI being designed to be the program that's going to predict what the next word is, right? It really has an impact. Like those, like disclosing the entire context, but blacking out sort of the key numbers might not be enough
Yeah, not
to
enough.
protect the trade secret, right? So it's interesting to see that happen.
And have you seen any M&As purely involving trade secrets where there's just no patents at all?
Absolutely. Well, so I wouldn't say no patents on the ones that I've been involved with, but the patents are more window dressing, right? So they're an accoutrement to the real value of the company. Um, we have a company that is based on how they manipulate uh, a herd of cattle, and you know based on the genetic manipulations all the way through the way that they maintain the cattle is really the value. Now we have patents that are directed to the products that come from this company, no question. But if you were going to ask me where the real value lies, it's really in the trade secret.
And I think especially with software and AI and all these fast moving technologies, we'll start to see like licenses that are purely trade secrets and M&A where all the value is in trade secrets, and maybe there'll be no patents at all.
That's right.
It'll be interesting to
I do
watch.
think that's coming. I do think that's coming. Now, the other place I've seen it, obviously, is if, it's interesting. I've been in this debate with a guy within my firm, Paul Stedman, who's a litigator, who, and he's right, trade secrets are not property, right? It's a tort is required for you to, sort of enforce whatever rights you have in the trade secret, which means misappropriation. So, this concept of treating it as a piece of property is a convenience for us because sure, we can create a privilege log of all of our trade secrets. We can treat them differently, but if a tort doesn't occur, it doesn't have any real inherent value,
Sure.
right? So it's kind
Yeah.
of It's kind of interesting. I think ultimately, um, you know, there's there's going to be it's largely going to be associated with a complementary value. Now, trade secrets may have the majority of the value. An algorithm, as an example, the trade secret is the real value, but what it produces is also valuable. So I think that comes into sort of a might be a branding issue or trademark and copyright associated with it. So I think, and the way I perceive it is, um, the real foundation of your IP is the trade secret, and the property rights that you and I have spent our whole career developing, right, is a result of that know-how in the trade secrets.
And I think that it's easy for us to say, oh, it's another type of IP, just like patents, trademarks, and copyrights that all have the traditional like infringement model or landmine model where someone copies or infringes your IP and they step
Right.
on the landmine. But
Right.
trade secrets really are a whole different animal, and it's
Whole different.
much more like theft than
Yeah.
stepping on a landmine.
Yeah. And I mean, think about it. When you and I, as patent lawyers, for years have told our people that if you're going to go into a discussion and you're going to disclose information, you need to mark your bills. Now, the way we would typically do that is we would file a provisional application, right? Um, but um, the same thing has to be done as it relates to trade secrets because Yeah, we will. What the purposes of us marking our bills and filing a provisional application going into that relationship is so that we can identify what we brought to it.
Correct.
That doesn't mean we're going to mature those rights into actual patent rights. And so, what we brought to the table, to the extent that it was a trade secret or confidential information and is maintained that way, has to be associated with our trademark policy, how we, the confidentiality agreements associated with the exchange of that information, um, the way we educate internally. So it's kind of interesting because when you and Tim started this process, I, like most patent attorneys, sort of thought about trade secrets as, kind of a complementary aspect of patents, but not really the focus of the value. More and more in this knowledge economy and how quickly things get developed and how slow it is to get a patent and how immediate relief is required, trade secrets have become much more important.
Yeah, and I think also, like, our bias is to think about technology because of
Yeah,
our education and history and track record. But all those business trade secrets that some IP people will say are kind of boring or soft trade secrets are more often litigated. So,
yeah,
like, they're not sexy and flashy, but things like, customer relationships, vendors, pricing models, pricing algorithms, even M&A strategy, going back
absolutely.
to M&A again, those can be wildly valuable trade secrets, even though they have nothing to do with technology. Certainly for me, that was kind of a mental adjustment that I had to make to start thinking of these because 5 or 10 or 20 years ago, if you said, "Do you care about customer lists?" I'd be like, "Of course not.
Yeah,
They're
yeah,
not patentable. You can't trademark them. I'm
right,
not interested." But
right.
now I realize, oh, those assets are actually stolen very often,
That's
and
right.
they can have tremendous value for the client.
Yeah, you're absolutely right. And it's it's interesting. There's a real disconnect in legal departments, you know, particularly outside the U.S. Inside the U.S., it's you largely have legal departments, you know, from a technical perspective, where those guys went to law school and they know sort of the broader concepts of tort and misappropriation and things like that. But in many companies that have roots outside the US, their legal department is focused on that, but their patent department is focused only on the technical issues,
That's right.
right? So I have found it a little challenging because my connections typically in, big companies outside the US are rooted in either in the technical arm of the company or they're rooted in the patent arm of the company, which that's not their job to think about trade secrets, just like it wasn't our job 20 years ago to
That's
think
right.
about trade, right? So that's been an interesting aspect, um, to integrate those two thought processes that it is important to protect the trade secret, and that's ingrained in the patent system and in technical systems because when we went to grad school we kept notebooks, right? And those notebooks went on a shelf somewhere, and that wasn't really for public consumption, right? It was really for the lab's benefit. But that's not the way uh, the legal departments would normally function, right? So it's been a bit of a disconnect trying to connect those two, and I actually think that, um, with the introduction of AI into the legal field and the importance and the timelines associated with trade secrets versus patents, once those two concepts merge, you're going to see an explosion in the value of the trade secrets. There's going to become registries, all of the things that we've talked about that are the enhancements of trade secret. Right now, we're just trying to get people to do the basics,
That's
right?
right. Yeah, nothing
Because
fancy.
we're,
Just
yeah, we're really not doing the basics, and you see it.
mhm.
I've seen it in M&A transactions where people are just blown away when they ask the trade secret questions, kind of trying to stump me, Do you have trade secrets? Well, of course we do.
Yeah.
Well, could you identify them? Well, of course I
Yes, we
can.
can.
Do you want to see my privilege log of my categorized trade secrets? I'm happy to share that with you. And they don't know what to say. And it then becomes a check the box issue, which, in an M&A transaction, as much as you and I like to be the center of attention, um, what we want our patents and our trade secrets to be is check the box. Let's move on to the really
Sure.
important thing, which is the commercial aspects of the company. You know, so it's pretty interesting.
Well, and if you have clients either on the acquiring or acquiree or acquirer side, like what kind of general advice would you give them about trade secrets, or what can they do to make the M&A process more valuable if they're being acquired, or just go more smoothly?
Yeah. So, I mean, immediately put a policy in place, right? Depending on how close you are to the transaction, let's do an inventory. And, tangibly has helped me, because I start on the technical side, where the first place that I'll create trade secrets are those patent applications that I decided not to proceed with, right? So now I have a documented trade secret that written up and maybe in provisional format, but we never then went forward. So already have a trade secret record. So, doing that inventory at the outset and then the interrogation of the company to figure out where are the trade secrets within the company. Let's identify them. There are some really cool aspects to what you guys do with, the X-ray as an example, right? Looking at your own patents and identifying things that aren't there, so are probably good categories to start thinking about. Why didn't you include them? And let's give a little detail to that, right? So create that inventory, that privilege log, as I refer to, because I'm not going to disclose the trade secrets to the acquirer until we get into a position where that's appropriate. But it becomes policy, sort of audit, and if I have enough time, education. Right? If I'm approaching an M&A, I probably don't get to the education part, frankly. I gotta have that policy in place, because that's always a question on M&A. How do you handle your trade secrets? We typically do handle them the appropriate way, and there typically is some form of policy. But let's make sure that we have a policy that we can hand over, so they can check that box, and then let's do that audit so we can identify those things that are important. It definitively adds value to the transaction.
Yeah, I think however many trade secrets you think you have, it's actually 5 or 10 times more.
You have exponentially more.
Everyone always underestimates. No one ever
That's right.
overestimates how many they have. Yeah,
Yeah,
if you think you have 5, you probably have 20.
that's right. That's exactly right. And I mean, it's a good exercise for you to understand where your value is. The other thing it does as you go into those transactions is keeps people mindful of the fact that they don't need to disclose all of their trade secrets. They need to identify them generally, but they don't. I mean, when you get in these M&A transactions, it's amazing to me how much people want to talk about how smart they are, right? And really, what the acquirer wants to know is, have you taken the steps to protect your trade secrets? Can you identify them? Can I identify them? And if I agree that they're valuable, can I make sure that they'll retain their value? Whether that's through, following employees, retaining employees, maybe morphing it into a patent, whatever. But that's really what they're thinking about.
Yeah, and we see the same thing with NDAs, which is admittedly a whole nother podcast topic.
Yeah,
Of,
it
once
is.
the NDA is signed, people are like, "Yay, I can disclose everything and convince everyone how brilliant
Yeah,
I am." That's like the
exactly.
last thing you want to do.
Exactly. Absolutely.
Well, this has been great. I appreciate you taking your time and
Sure.
getting your perspective. And as you can tell, we're all excited about trade secrets and glad to have you part of that journey with us.
Yeah, I think. I mean, I think you guys are on the front end of a transition and a transformation. Um, you know, uh, just the time. If you think about it from that perspective, the time that it takes now to get and enforce a patent. I mean, there's technologies that have emerged, been exploited, valued, and went away, and the time that it would take for that
much
stuff
less.
to happen, right?
Totally.
So yeah, it's pretty cool. So I'm excited to be here.
Awesome. We'll talk soon. Thanks, Ray.
All right, buddy, take it.